In the spirit of reconciliation, Law Squared acknowledges the traditional custodians of country throughout Australia and their connections to land, sea and community. We pay our respect to their elders past and present and extend that respect to all Aboriginal and Torres Strait Islander peoples today.
Hello and welcome to The Right to Disconnect, From Legislation to Practice, presented by Law Squared. I'm your host, Employment and Workplace Relations lawyer Amogh Kadhe. As you will no doubt be aware, the Fair Work Act has recently been amended to close certain loopholes. We saw the first tranche of changes come into effect at the end of last year with the passage of the Closing Loopholes Act 2023, and now with the passage of Closing Loopholes Act 2024, which received royal assent in Feb this year. We've seen some further changes, with one of the big ones being around the right to disconnect. To help organizations align with these and other looming employment law changes, I'm joined today by two very special guests, both of whom bring real-world experience from both the legal and people and culture perspective. First up, Grace Q, who joined Oxfam Australia People and Capability Team in November 2024 as People and Capability Business Partner after 6 years of working as an employment and workplace relations lawyer here at Law Squared. Fair to say that Grace has seen both sides of the coin when it comes to HR, IR, and employment law issues playing out in the workplace. As an experienced advisor and strategic business partner on People Matters, Grace likes to act proactively with a view towards workforce planning and looking to what is coming on the horizon next, which is often easier said than done when it comes to industrial relations and the employment law landscape. Grace has seen the difficulties that the new closing loopholes changes have brought, including the right to disconnect, for both employers and employees alike in her multidisciplinary experience, but she revels in the challenge to make these changes accessible, understandable, and most importantly, workable in a practical way for Oxfam. It's great to have you with us again, Grace.
Thanks, Amogh, for that introduction, and really excited to be here.
Next up, we have my fellow Law Squared colleague, Andrew Brooks, who's also a workplace relations lawyer here. Andrew will be well known to many of our viewers, having worked extensively as a legal advisor to many of Law Squared's clients across both for-profit and not-for-profit sectors. Andrew is the co-author of the Child Safety Toolkit 2018, which has been downloaded over 100,000 times and aims to prevent child abuse in community organizations. Andrew is also the driving force behind a whole library of free resources published at Law Squared, aimed at helping organizations comply with employment legislation and emerging trends in the workplace. These include the Family and Domestic Violence Leave Policy, the Artificial Intelligence in the Workplace Policy, and most recently, the Right to Disconnect Policy template. Prior to becoming a lawyer, Andrew worked as a personal carer for Australian Home Care for over 5 years and is passionate about supporting differently abled people in our communities to live prosperous and fulfilling lives. Thanks so much for joining us, Andrew.
Thanks for having us, Amogh. Appreciate it.
Now, for the viewers' benefit, the intent of today's webcast is not only to provide practical advice for implementing the right to disconnect, but to also discuss the level of what this level of change signals for the evolving Australian employment law landscape. And in particular, what employers need to start doing now to not just achieve compliance, but how they might turn this and other workplace changes to their advantage and indeed become an employer of choice. Finally, given the respective experience of both our guests, I'm also keen to get their thoughts on how legal, be that in-house or external, as well as people and culture professionals, can best work together to embed lasting change. I imagine all our listeners will have heard about the right to disconnect in recent weeks and months. I don't think it's an exaggeration to say that it is a groundbreaking amendment to the Fair Work Act and the Australian employment landscape more broadly. Andrew, I'd like to start off with you first. Would you agree that this change is quite significant in terms of how it's going to affect the employment landscape? And perhaps, can you give us a little background on what specifically has changed with respect to the right to disconnect and when those changes come into effect?
Okay, amazing. And great questions, Amogh. I feel like I could talk about both of those forever. I might start off being a little bit on the boring side and say that I don't necessarily agree that this is as big a landmark decision as some people believe. So maybe first I'll go through what it is and then potentially more importantly, what it isn't. Because the headline, right to disconnect, sounds very nice and it sounds very impactful, but it's actually a lot more complicated and grey than that. So in terms of what it is, so from the 26th of August of this year, and then you've got another 12 months for small businesses, so 26th August 2025, basically employees are able to not respond to unreasonable out-of-hours contact. So if you simplify it, it basically means that annoying managers can be left on red if they're unreasonable. What it isn't is the ability, and in my head when I first heard about it, I thought if you had a work phone and a personal phone, you could basically leave your work phone in the office and then go home and then basically disconnect completely. And that feels like a real right. What we have, though, is not that. So there's no ability for every employee in Australia to basically switch off completely. It's all based on all of these different criteria. So there's a reasonableness aspect to it. So in terms of whether out-of-hours contact is unreasonable or reasonable, they'll look at a various number of things, such as how much money do you get paid? So if you're a CEO on $600,000 a year, probably more likely that it's reasonable for you to respond to out-of-hours contact. But if you're a first-year nurse who's earning minimum wage or minimum rates under the award, it's probably unlikely or unreasonable for you to have to respond to that. So there's that reasonableness in terms of pay. There's that seniority piece. So again, a CEO versus a first-year grad. More reasonable for the senior person to respond. They'll also look at your roles and responsibilities. So what's actually part of your PD in terms of out-of-hours contact. And then also just flagging, it doesn't actually capture messages in relations like rostering. So it doesn't allow you to just basically not respond to any messages about rostering. That's kind of excluded. And then there's more exclusions as well. So you can kind of see as we kind of go through this, it's not quite as simple as leave your work phone in the office. So we have a lot of clients that kind of responded really dramatically to this news. They were saying, well, let's get rid of all of our flexible work arrangement practices. This is the death of flexibility. No one can work anymore in a nice way. But it's not actually that. So yeah, a lot of countries around the world, which we'll talk about, have gone with a different approach. But maybe just in terms of that initial what it is and what it isn't, it's a right to reasonable disconnection, which is very different to a right to, say, not suffer bullying or right to not suffer sexual harassment in the workplace. There's no reasonableness element to that. This is actually a little bit more limited. So yes, articles, the headline may make you think this is bigger, but it's actually, as I said, a little bit more grey. So hopefully I answered that a little bit.
No, definitely. And thank you for clarifying that and sort of sharing your perspective on that. I would like to press you a little bit further on it as well. What do you think is really driving this change? It's obviously a significant departure from our current practice. Do you think Australia is catching up with the rest of the world? And do you see any broader sort of employment trend where employers' rights are kind of winding back with respect to what they can and cannot do?
Yeah, it's a really interesting point. I don't think necessarily that we're falling behind in terms of right to disconnect. There are countries in the world that have it. I think Thailand has it. Kenya is the first African country to bring it in. So it's not necessarily new. But again, I think it's just one small piece of the landscape. So I think what's actually pushing it is that employers are still pretty bad at paying people correctly and complying with the main kind of basic tenet of employment law, which is if you work, you should be paid for that work. So that's always been there. And that's why sometimes I push back a little bit in terms of the significance of this particular change, because the obligation to pay people for doing out-of-hours work has always been there. And we may still get employees and employee rep firms actually push that angle instead of this right to disconnect angle. So in countries such as France, what they've seen is that they're actually still going down. They'll work it and then they'll claim overtime for that work. They won't push back against the actual request. So I think what's driving it is basically fair pay for fair work. And that's arguably kind of the logic that the Greens Party used when it tried to push in this amendment. But it's not necessarily its own piece. I would like to think of it as just one piece of a much larger puzzle of compliance rather than its own separate kind of major overhaul. So, for example, and not to talk too long, but the Wage Inspectorate of Victoria has come in. There's a lot of wage theft introductions being brought in Australia in relation to making sure that people are a bit more accountable for underpayments. You've got the Federal Ombudsman pushing a lot more underpayment claims. I think if you Google underpayments in Google, you could basically see almost every major employer in Australia come up with a headline. So I think what they're trying to do is push people towards actually paying people correctly. And this is just kind of one aspect of that.
Perfect. Now, Grace, let me bring you in at this point. Now that you're sitting in the sort of people and culture space, can you give us a perspective on how you and Oxfam are looking at the right to disconnect? What do you foresee as the biggest changes and challenges?
Yeah, perfect. Great question, Amogh. And thanks for that overview, Andy. I'm glad I've got the same idea about what the changes are, so that's great. I might start with sort of giving a bit of an overview about how we work at Oxfam Australia. So we've got about 150 odd employees in OAU, and sort of our largest areas, I suppose, in the organisation are the fundraising unit and the international programs unit. And then we've got a decently sized operations side of the business, including people and capability, which I'm a part of. As part of that team, we've got about a team of 7 or so that support the whole organisation, as well as some aspects of Oxfam in the Pacific. We provide support to Oxfam International, so there's competing, obviously, timelines and priorities there. But largely, we have a team of 7 in the team. We have quite a few individual contributors, so we have a payroll person, we have a volunteer engagement person and a safeguarding person as part of that. But beyond that, we really only have 2 business partners who provide that strategic support, not only to the 2 big units of the organisation, but then those other affiliates as well. But I think generally speaking, not-for-profits are traditionally resource constrained. So it's good that we have these changes, but I think the first step really here is about understanding the changes before you actually embark on anything. So that might be through in-house expertise, and if you don't have that expertise in your people and capability or people and culture team or your legal team, it would then be considering, okay, if we don't have the resource in-house, it might be going to someone like Andy or yourself, Amogh, to try and make sense of those changes. So I think really understanding them is the first step. The second step around it would be, depending on resourcing, just understanding the practical implementation of that in your own context, because that's going to be really different business to business. It's going to be different if you're an NFP or an INGO like we are versus a corporate who might have a bigger budget, might have a bigger group of people that they can use to actually implement this. But I think thinking about how it can work, how it might rear its head in certain parts of your organisation, and being able to convey that to people managers and the like in terms of what they need to do and the timeframes as well is really important. How I think it might potentially come up in our circumstance as an international NGO is, I think, potentially in times of crises. So there's circumstances where we potentially may need to quickly mobilise with the global humanitarian team, which is part of Oxfam International, and work with them, or potentially, our marketing side of the organisation or the fundraising side, we might need to stand up an emergency appeal. So there's obviously circumstances around that where work outside of our normal span of hours might be required or requested. We also might have time where, when we're supporting those country teams, potentially in the Pacific or potentially something like Oxfam Great Britain, there might be something urgent that's happening there that we actually need to mobilise and act upon. And that's something that we really grapple with in the P&C team as well. But again, just working across those timeframes and those priorities as well that are competing across the Confederation. So working across those time zones is quite difficult at times, and there's definitely work that happens outside of the span of hours. So we've got to think about that. And that sort of goes to the implementation piece, right? That could be through a range of different mechanisms. It could be through training, either in-house or external. It could be through further education or drop-in sessions, I'm thinking more practically. But other than that, it would definitely be, at a very base level, socialising this with the people managers, right? That might be in the one-on-ones that the business partners have with them to try and help them, again, understand the changes, understand what their obligations and they need to be doing around that reasonable piece and what's reasonable and unreasonable under the law, which we know is not clear in any sense, but then also working out what's best for your people and what's best for the organisation, because really it comes back to that respect for people's private time, respect for people's work, and that balance, and just making sure that we're not overreaching from a behavioural or a cultural perspective, which can often be ingrained practices in organisations across the board.
No, definitely. And thank you for sharing that. Now, you raised an important point, Grace, around Oxfam, particularly that they are an NSP. Now, do you see, I might throw this off to Andy first and get your thoughts on it as well, Grace. Do you see any impact or challenges of implementing the right to disconnect varying across different industries between, say, for example, banking industry versus the legal industry versus some other sectors? So do you see how this right to disconnect is implemented sort of depend on the industry, I suppose?
Yes. Basically, absolutely, in terms of which industries will actually respect this or not. And we've seen this kind of fight happen already in terms of a lot of contracts have that you have to work 38 hours a week plus reasonable additional hours. And there have been a lot of cases in terms of what's reasonable. in terms of those additional hours. And they go through the same test. So like, what's normal for your industry? How much are you paid? So when you look at investment banking, for example, they've been able to interpret reasonable additional hours as, say, 15, 20 hours extra. But if you're in a disability support organisation, reasonable additional hours may be zero because you're just not paid enough to cover that. So I think the industry will be important here because the industries that push back against, employees having time off will continue to do that probably in terms of this right to disconnect. And the organisation, the industries that are less inclined to do that, like the NFB sector a lot of the time, they'll continue to respect people's out-of-time work. So the law applies equally in terms of the test. We're just going to see different uptake or respect by different industries in terms of how much they actually follow this. I'm sure that there are banks across Australia that won't even really care about this because they'll just say we pay enough, whatever our contact is reasonable. And, they may get that test in the courts, but there'll be other industries which will continue to be very conservative and make sure that all out-of-hours contact is reasonable. So I think that's where we'll see the difference.
And Grace, do you have anything else to add on that?
Yeah, so I think it's going to definitely, like Andy said, it's going to definitely depend on what industry you're in and how much weight they put on these changes. Like Andy was saying, it's not as significant or as landmark in my mind either as to what it actually is, but ultimately it comes back to those behaviours, right? And if you've got ingrained cultural practices of working 12, 14, 16, 18 hours a day, that's going to be a big change. But if you're already working through really good cultural practices of, respecting people's private time, respecting, they've got a work life and also a private life, and understanding those boundaries and people actually sticking to those boundaries, especially people managers, I think you'll have less of a hard time to actually implement this sort of stuff. But yeah, that's going to be different sector-wide. It's going to be different employer to employer, really.
No, for sure. And thank you for sharing that. Now, I'm sure we'll return to psychosocial hazards a little later on in this webcast, but I think it'd be interesting to hear your thoughts on whether you see the right to disconnect as a reaction or even a partial solution to some of the concerns around psychosocial hazards. Now, Grace, perhaps I can ask you to talk a bit more about how the inability to switch off can lead to psychosocial hazards. If you could tell us more about the kind of harm that this new law is seeking to protect employees against.
Yeah, that's a great question. I think there's a real link between the psychosocial hazards legislation that we've definitely been hearing about in Victoria for a while now, and so I think people are very attuned to it. And so I think probably one of the first connections they would have made was, okay, right to disconnect, and again, that respect for people's private life and that they've got a life outside of work. And so they have that, there should be that ingrained ability to be able to disconnect from work. But like Andy was saying, it's not a carte blanche. It's not you can leave your phone at the office from 5:01 p.m. onwards and the rest is your time, and then you come back at 9 a.m. and start all over again. I think it's more it's a consideration about how people work, ways of working, what's the best way for working in terms of your particular context and your people. And I don't think it's a complete, throwaway of things like flexible working arrangements either. I think it's making sure that people can have autonomy over their time and trying to work within the bounds of that to make sure, okay, we can still get our outcomes and the work that we need to done, but also what's that respect piece and that behavioural piece that feeds into the culture of an organisation.
Definitely. And I want to press you on some of those points a little bit more. When COVID descended, we had a lot of people switching to working from home or working remotely. And in the globalized environment today, where you have that flexibility and opportunity to work from home or work from any location effectively, do you think it's become harder to switch off? Because in theory, when you are in the office, you leave at a certain time and that's it. You come the next day again. So there's that very clear demarcation between work versus home. But since we have seen, flexible work take off, really, have you found that it's been harder for employees to switch off? Is it easier? And what are the sort of impacts of that challenge, I suppose?
Look, I can definitely speak to my own personal experience. I think the answer is a resounding yes, but it's going to be different for every organisation. So it's an it depends as well. I think personally for me, I'm a personality who thrives on, getting stuff done, being productive, being efficient in how I do things, but also I really like what I do in the same sense. So I'm more inclined to probably work longer than I need to, if I'm being completely honest. But I mean, some employees are really good at keeping those boundaries as well, and that should be their right. As long as they're getting their work done, they're working to the outcomes and the deliverables they need to, and they're doing that to the standard that we require. That should be, the be-all and end-all really with it. But I think with COVID, I think with the blurring of the lines between the work sphere and the home sphere, definitely it's created the circumstances and the atmosphere for that to happen. And so I sort of see this, I suppose, from a legal and from a people and capability perspective, I sort of see this as okay, let's bring people back to the idea that, you do have a work life, you do have a private life. We want to make sure that that is kept sacred in the sense of, this COVID boom of working from home, flexible working, and make sure that people can really protect that time.
Definitely. Now, there are undoubtedly some serious, physical and mental risks associated with employees not feeling like they're able to switch off. I'm sure we can agree that a workplace that does not respect that, as you rightly pointed out, Grace, sometimes there is that bit of a blur, but employers who can't respect that will generally see, employee dissatisfaction or even burnout at an early stage. But what about the exceptions to this? Say my preference is to work later in the evening, or, I just don't have time during the day to send that one email that I need to send to a colleague, which I end up sending after hours. Do I need to basically shift my entire habit? Am I not allowed to do this at all? Or is it okay as long as I don't expect that colleague to respond right away? So Andy, I might get your take on this. Are there exceptions to this, or is it more of a blanket rule saying you absolutely cannot email someone outside of their working hours?
So it's a great point, Amogh. It's not a proactive prohibition or an obligation. So it actually doesn't. And this is where a lot of the commentary, I think, slightly got it wrong, and at least initially. It almost tried to make it out like an employer is actually lawfully prohibited from contacting an employee out of hours. But that's not actually what it is. There's nothing proactive that stops an employer from contacting. It's actually on the employee to basically try to decipher what's reasonable or unreasonable contact and then respond to what they consider reasonable. So that's, I guess, the important distinction for that point. And I think it raises really interesting questions in relation to flexibility, because I think a lot of the time why employers immediately got quite defensive in this space is that they said, well, we're giving you a lot of flexibility during the day. Like, we all know that employees working from home sometimes hang out the washing, they do appointments, they walk the dog, and now you're going to turn around at 5:05 and say you're not responding to my messages. Like, as in, I think employers a lot of the time initially, they wanted a bit of give and take. So yes, we're giving you flexibility. We're not harping on your hours earlier in the day, but it is nice that you're able to respond to something later. And now I think we're seeing both sides kind of feel their way out from this, but it's not a blanket rule saying you can't contact employees after hours or a blanket rule that they don't have to respond. It's actually all based on that reasonableness test. So if you were, say, for example, being a workplace that had so much flexibility, people started late, started early, it's going to be a bit more complicated in terms of what's reasonable out of hours, because an employer might say, well, you started at 11, you didn't start at 9, so it's reasonable for you to respond at 5:05. So I think that would then come into it. I don't think this is a way for employees to start later and then end earlier. In the same way, I don't think it's a way for employers to always be able to contact employees. It's, again, we're kind of dealing more in the grey than, I guess, what some of the kind of commentary kind of points out.
Definitely. Now, most organizations I've come across are usually well-intentioned and genuinely care for their employees' well-being. But oftentimes it is poor practices that creep in and over time and gradually sort of change expectations. Andy, perhaps you can talk a bit more about the risks of employers not getting this right. What are organizations who don't provide that buffer between work and private life risking? Perhaps both from a sort of general humanitarian point of view, but also from, what sort of penalties might they attract or any kind of disciplinary action that they might be subject to?
Yeah, sure. So maybe I'll start with the legal one, because I actually think that's probably the lesser risk in this space. So let's say, for example, that you have a manager that constantly contacts an employee out of hours unreasonably, and then basically just builds up, and the employee tries to deal with it internally, but still have a manager that kind of toxically tries to contact you. They can go to the Fair Work Commission to lodge this application to try to get them to effectively order the employer to stop contacting them out of hours. And then if they breach that, there's, say, an 11,000 or so fine that can apply to that. But again, it's similar to the stop bullying or stop sexual harassment orders. They're actually not used very often because there's an awkwardness, I guess, to it in terms of this is an ongoing relationship between an employer and an employee. And if you've gone all the way to the Fair Work Commission to basically get them to tell you to stop doing something unlawful, a lot of the time it's not a great predictor of a long-term relationship between the two parties, because obviously something is broken down there. So what's more of a risk is an employee will basically not respond to something, get performance managed, potentially get terminated, and then they'll make the link there, similar to what we've seen a lot in general protection space, but they'll say, I was terminated because, and then they'll link it to one time they refused to respond to a message from their manager. And then it'll be on the employer to show that they actually terminated for a lawful reason, not because of that protected right. So that's where I think the risk will be from a legal space, is that you'll terminate someone, they'll link it to a refusal. And then the risks in general protections are uncapped in terms of compensation. So there's no kind of cap like in unfair dismissal, which is 6 months. And then penalties can apply. And I just flagged that they can apply personally and to the company. So if you're a head of HR or legal counsel that was directly involved in what happened, you potentially could be brought into those proceedings. So in my head, that's the legal risk. So it's less about the stop orders that will come in, because I don't think they'll be utilised very much. It's more in relation to general protections claims. But if I flip it, and Grace will be better able to talk about this than me, whenever you've got a toxic manager, because I think a lot of these laws are set up for a toxic manager who will just basically have no regard for their employees and send ungodly time requests to their employees, is you'll just lose good people. So I think a lot of culture is sometimes the absence of a bad culture is a good culture. And I think if you've got a manager that's just unreasonable in terms of their out-of-hours contact, they continually contact and harass their employees, they'll just leave, I think, eventually. Or you'll have to keep paying them such a high amount that it then becomes not profitable. So I think that it's a people risk largely. I could sit here and say that also there's an OH&S component to this as well, which I think is true. But arguably that was already in place beforehand. So all employers have an obligation to provide a safe workplace, and that includes those psychosocial hazard risks. And yes, Victoria is a bit late to the party, but other states have already brought in their codes of practice. There's a potential risk there that WorkSafe or Safe Work will come on site and basically allege that you've created an unsafe environment due to the out-of-hours contact. But I think that's probably less likely than the general protections risk, or less likely, again, actually losing good people, because we all know how much it costs to replace people, to hire recruiters, to train them up. It will be much bigger if we think about it from that practical point of view, rather than the $11,000 penalty for failing to follow a stop order. So I think it's actually bigger than just legal.
Definitely, and quite rightly said as well. Now, Grace, we've spoken about the aims of the right to disconnect and the risks of not getting it right. But with all this in mind, what are going to be some of the big challenges for even some well-intentioned employers out there who are wanting to implement this? What challenges do they face, even though they want to kind of be proactive or want to implement this policy in a proper manner?
Yeah, absolutely. Great question. And I think, Andy, just to go back to the question just before, I think you hit the nail on the head. I think it's going to be a real people risk and potentially losing good operators, really. And then that has all the costs that go on to that. But moving to this question, I think one piece of it will probably be strategic alignment. That's not only within your P&C strategy and where that might fit potentially, because this sort of obviously seemingly came out of the ether, to be completely honest. But it's not as monumental as it seems, which is good. I think it's just considering, what's reasonable, what's not reasonable, and making sure you train people up on that and continually touch base with them. But also not only the P&C strategy, you've then got your organisational strategy. Where does that fit as well? And that's something we're considering at the moment. Another element to it is, how are you measuring and reporting on this? Is this through your employee NPS or your Net Promoter Score? Is this through behavioural alignment surveys? Is this through, stay interviews or exit interviews? How are you actually determining if your approach is working? What are the measurables you're looking at? Are you revisiting this for the best operation possible? So I think that's a really key element to it as well. So that's going to be a challenge for people, especially if they're in resource-constrained roles, which P&C often is, especially in the NFP sector. So you've got to consider, what things can you tackle first? Things can you kick down the can and tackle later as well, considering the OH&S and the people risks. But I think the main thing around this, and this will depend on your workplace, is the behavioural alignment, really. Again, it goes back to what's the ingrained practices in your organisation, what's the culture like now? Are people working insane hours a day in a wholly unsustainable way, or are they actually working, they're 9 to 5, they're getting their job done? What's the budgetary impact? What's the people impact? How are you, right-sizing jobs, or are you properly sizing jobs in the first instance? Have you got enough resourcing? I know there are a lot of questions that I'm just throwing out, but I think they're all key questions to consider in the context of the behaviour, because if you've got budgetary constraints, if you've got resourcing constraints, if you've got insane workloads that people are working to at the moment, you've got to work on those at the ground level before you can even do anything proactive and workforce planning wise around this. But if you've already got a good base you're working to, you've already got a good culture and a good base to work from, that's going to change how you go forward, and you might be able to do some more forward planning as opposed to being reactive to this. But yeah, I think it's definitely got to be a discussion about priorities in teams as well, especially if that workload thing is a real gripe for your organisation.
Definitely. And I think it's an interesting point, because I know that one of the things I was mentioning at a recent CPD I was at was that, having the right to disconnect is quite useful, but then you don't want it to... You don't want employees to think about their workload if the workload is not managed properly. Like if you've got an insane amount of workload, just because you can clock off at a certain time doesn't mean you're not going to be thinking about work itself. And so employers need to be alive to this issue as well, that they need to consider, managing the workload appropriately as well. So it's not just having the right to disconnect almost like in a bit of a silo, like you rightly mentioned, both of you. You have to think of it from other perspectives as well, and cross teams as well. So definitely agree with that one. Now, we've kind of talked about what the right to disconnect is and sort of the risks and the sort of challenges. But what would you advise employers about navigating this change? I wanted to get your sort of takes on this, both of you, in terms of what can employers and businesses start doing to prepare for this now? And I might start with Andrew on this first.
Yeah, for sure. And I'm just conscious that I think the much harder task will be the Grace HR side than the legal side, just because so much of it is behaviour, Grace said. It's actually about trying to prevent bad actors, so those toxic managers, from actually behaving unreasonably. I don't think it's as much as, say, having a policy and then that will do everything. I don't think that will necessarily be it. But in terms of the legal side, I think you may have, like before, Amogh, Law Square released a free right to disconnect template, which anyone can download. And I think when you read through, you'll see that the way we start, intentionally so, was to take it away from saying that employees have to respond or don't respond after a certain time. It was more trying to make sure that we get information as employers as to whether employees think contact is unreasonable or not. So we don't want it to go straight to the Fair Work Commission. Like, of course, employees have the ability to do that, and no one's trying to take that away. But I think you lose so much of the relationship sometimes by not trying to deal with it internally. And we want policies that back up and encourage people to come forward. And if they think that a manager is contacting them unreasonably out of hours, or even worst case, threatening disciplinary action for not responding, we want to know about that as early as possible, because if it is unreasonable, then we can take action against that manager. And if it isn't unreasonable, so it's actually reasonable contact and it's 501 and they're paid crazy and they're the CEO, then we actually want to be able to have that conversation with the employee to set through why we believe that's reasonable, so we can try to prevent it from going down the Fair Work Commission route. Or worst case, lodging a workers' compensation claim due to burnout or stress, and then they're just off for more than 6 months. So that's kind of the part that I think is really important from a policy point of view, is to have something in place to encourage transparency so we actually know about issues. And then besides from that, it's to fit it in terms of our bigger OH&S piece. So psychosocial hazards is kind of a buzzword at the moment. A lot of information work will go into that. A lot of employers are more on top of that, as ever before, and they will increase. But part of that is also carrying out a risk assessment on psychosocial hazards. And one of those components, or one of the hazards that a lot of our clients deal with, is overwork. So basically the people are getting too much work, or they're not able to switch off, they're suffering burnout. And so as part of that, what are the ways you can kind of reduce that? So yes, policy would be one of them, training for managers potentially on what's acceptable or unacceptable out of hours contact, moving through in terms of expectations. So, and not to get too Instagram relationshipy, but a lot of times relationships break down even in the work context when there's unmet, uncommunicated expectations. So we're getting upset at employees for not doing something which we've never told them that we want them to do. So I think if you take that back to the beginning, are we being clear in our position descriptions that out of hours contact may be required? If there is a global disaster and we work at a not-for-profit that has different time zones, do they know that they would therefore be required to get on calls late at night for that particular emergency? So are we actually communicating that clearly? Are we setting our salaries to reflect those out-of-hours contacts? Because again, they'll make sure that it's more reasonable than not. And that could be bumping up the annual salary. It could be setting a situation of what happens when out-of-hours contact happens. So whether you've got a time off from lieu policy or extra pay that kicks in, putting some more thought into how that kind of works will, again, better protect you from not only a right to disconnect stop order, but also just that you're paying people correctly. Because again, that largely, this is just one piece of that larger puzzle. So I guess, yeah, if I was to summarize, I think from a legal perspective, having a policy, carrying out a psychosocial risk assessment, making sure your PDs are up to date and reflect what the actual role requires, and then having a bit more of a think through in terms of their employment contract and their pay in terms of how you can appropriately remunerate them if out-of-hours contact does happen. So yeah, that would be my really quick snapshot. But again, I think the behaviour piece is actually more complicated, and that's why I'm glad to be sitting on this end of the legal sphere and not on Grace's end of the HR sphere. I reckon that's way harder.
No, thank you. And thank you for sharing that, Andrew, and also for mentioning Grace. And I will now turn to Grace, actually. So how are you at Oxfam already starting to think about the right to disconnect? Perhaps in particular, what do you see as people and culture or HR teams' role in embedding the right to disconnect within their organizations and workplaces?
Yeah, perfect. Thank you. And thank you, Andy, for recognising that the HR side is quite difficult. I've come to realise that as I've jumped to the other side. But look, I think Andy's absolutely correct. I think you've got to have a base level of understanding to begin with, to be honest. And that's documentation, that's training, that's realignment of expectations. So I think those are the three big things. But I mean, if you've got documents, if you've got training, if you've got stuff there, like that's just one piece, and that's the base minimum you probably should be doing, really, because I mean it does come back to OH&S, it does come back to people's behaviours, it does come back to what's reasonable and what's unreasonable in the circumstances. So this is going to be something that's going to have to be evergreen, and that you're going to have to do a constant reevaluation on the approach that you're taking to ensure that actually, you know, does what it says on the tin, right? So if you're taking a particular approach, you've got all that documentation in place. If you're not actually doing anything with it, you're just kind of putting it aside and you're not actually training people on it. You're not constantly having that discussion with people in your one-on-ones. You're not constantly evaluating, hey, what's the workload like for you, working out what might be a better flexible approach, and, you know, name-checking poor behaviours, but also championing good behaviours. You won't be able to actually properly implement it practically, really. I think it sort of comes back to what we were talking about. I think the role that P&C or HR can play, definitely, because they're in the business, is helping people understand the obligation first, but also understanding what good modelling looks like and what good modelling looks like within their own practices and behaviours. If you're not modelling that as a people manager, and you're just saying, oh, you know, don't work beyond your work hours, don't do this, that and the other, but on the flip side, you're working at 9, 10, 11 p.m. at night or first thing in the morning because of the workload or the work that you're working on because you haven't got your priorities right, that's unsustainable for you. And then it's just going to create a perpetuation of behaviours around, you know, your team or your direct reports feeling like they need to be available as well. So it kind of just goes completely the opposite way and goes completely out the window and will just lead to poor people outcomes for the organisation all round, like Andy was talking about as well. But I think there's an element to this. Yes, P&C have a very big part to play here in educating, in constantly reevaluating, in reporting on this to people like the board and the CEO. But I think also the P&C shouldn't be the police here is another thing. And I know that it's gotten a bad rap in the past around this, but ultimately people managers have gotten where they are because they might be good individual contributors and they might be good at that people side of things, of course. I mean, there's exceptions, but everyone's an adult who's in that type of role and they're there for a reason, really. So I think if you've already got those good behaviours, it won't be such a big shift, and P&C will probably just be leant on. It probably won't be as big a play for P&C there, which is good. But if you've got all of these risks around behaviours and workloads and unsustainable practices, it's going to be a much bigger shift that you're going to be focused on. It's going to be a much bigger change in the cultural norms and the ingrained practices you've got in order to mitigate those risks that Andy spoke about.
Certainly. And I think I want to ask you one follow-up question on that, Grace, which is what can employees do to kind of, I suppose, feel more comfortable in having those conversations with their employers? Because as you both rightly mentioned, it is about communication. It is about transparency and clarity around job expectations, about, those sorts of things. But what can employees do because it's a new change for everyone, I think, at least as far as explicit change is concerned. You've never had a right to disconnect explicitly in law until now. So, how can employees have those conversations when they feel like they need to? What are some tips and tricks for them?
Yeah, I think it definitely goes both ways. I think you're right. And I think clarity from both sides, like there's a saying that clarity is kindness, right? And I really understood that coming into a business, because if you're not clear about the expectations, whether it's employee to manager or manager to employee, it's going to make for a difficult people relationship ultimately. And that's going to cause issues down the track, legal or otherwise potentially. So I think clarity is a real key thing. I think keeping the lines of communication open is really important as well. And if you feel like you can't do that, I think it's important to speak up. And whether that's to PNC on a confidential basis, and so how we can help sort of reset those expectations around communication or clarity or, jobs as well. But I think there's also a piece around, if you feel comfortable speaking to someone who's higher up as well, that might be another piece to the puzzle. So I think it's also just considering what your relationship with your manager is like. And if it's positive, that's great, but it can always obviously improve. If it's not so positive, it's speaking up at the moment and just being flexible about the approach, because this is a disruption really to the legislation. People are grappling with it. Yes, it's not as big as the commentary says, but it's still something that's a change, right? And people love to go with what's happening right now, go with the default. So there's going to be an adjustment period, like any change that you've got in an organisation. But if you're flexible about it, if you're open and you're honest in your communication with your managers, employee to manager and manager to employee, I think that's going to go a long way with this, to be honest.
No, definitely. Now, it seems as though the interface between legal and people and culture teams is becoming more and more important, not just with respect to the right to disconnect, but also the other changes that have recently been enacted, such as fixed-term, master-term contracts, or flexible work, etc. I'm going to stay with you, Grace, on this one as well. You've had experience now on both sides of the aisle. Can you talk a little bit about how you see the relationship between people and culture and the legal teams in your organizations? What makes for a successful relationship within those two teams?
Yeah, so I might talk a little bit to internal and external as well. So, for example, internally, I'm the BP for the legal team. So we work quite closely on people matters, not only within their own team, around resourcing, around recruitment, around succession planning, which is obviously a move from what I was doing previously on the black letter law, but that's obviously built a good relationship with them, but we also work closely with them on people matters themselves. They might be complex or controversial. So it's really good, and I think it really helps with that flow of information from a legal side, but also from the PNC side. So it helps with upskilling in that sense. Externally, I still think it's also quite important, obviously, especially if you don't have the expertise in your PNC or your legal team in-house. Like there's always things that come up with people, because people are just people, right? And inevitably there's going to be argy-bargy over certain things. And so I think having that trusted advisor externally, especially if you don't have that in-house, is still really important. So building that relationship with a trusted employment lawyer is really key, because sometimes, especially in NFPs and INGOs, you're resource constrained. So if you've got all these changes, like the closing the loopholes 1 and 2, that have come out of nowhere really and changed the landscape completely in some senses, if you don't have the time and energy to actually digest those changes for yourself, how are you going to be able to explain that to other people? So that's where you might be able to lean on a good employment lawyer, either internally or externally. But I think in terms of this as well, like it's really good that I've had both sides, because I can see the practical and the theoretical now. And it really helps me with trying to craft my advice to internal stakeholders, because I've come to realise, rightly or wrongly, no one cares about what I care about, right? So they have little time, they have little brain space to digest this, and they are absolutely not as interested as I am. And understandably, they are doing amazing things in the fundraising and in the program space or in the operational side of the business as well. So they don't have the time or energy to actually digest what I'm saying. So the main thing for me has been making sure you're doing things actionably, making sure you're being clear. Again, clarity is kindness. And, you know, they're really the success factors around it, other than making sure that you've got those trusted relationships with people as well. So people feel comfortable to come to me on things as well.
Definitely. Great points. And Andrew, any thoughts from you on the legal/people and culture interface? What about those organizations that don't and maybe have an employment lawyer or an in-house lawyer within them? What advice do you have for those sort of people and culture leaders within those organizations when they are thinking about what kind of legal support they need or would like to navigate through some of these changes?
Yeah, that's a good point. And guys, I'm sure we have similar things in interest being employment lawyers. I think we're nerding out in this area probably more than most. And that's always my biggest concern, is that employment lawyers get into employment law changes more than people actually care about. I think, therefore, if we're fighting over the nitty-gritty in terms of what's reasonable, and then most of the people in culture teams or employees don't care because they've got other things they're working on, then is it even that important? But yes, I agree in terms of tailoring the approach based on what your in-house capabilities are, because I think a lot of lawyers immediately come and they say, you should bring in an external employment lawyer for every single matter, and that's the best thing in the world to do. But I just don't think that's reasonable, or normally the best. You know, like, why would you bring in an employment lawyer if you have that capability in-house? And why would you think that an employment lawyer externally would know the relationship between you and your employees better than you would? And so I think I see employment lawyers external as only being there as a bit of a top-up, or for those really specialised high-risk matters where you do need extra help. Because especially in this space, I think we will see employees use the words right to disconnect incorrectly and then use that as a basis to allege all sorts of things, and then actually also just be a terrible performer. Or they might bully other employees, but because they feel like they've used the words right to disconnect, they might feel protected. And yes, those risks are incredibly high, probably because I've used those words, and we kind of get a foreshadow that they might be litigious. So it might make sense at that point to think about external counsel. But for a lot of it, hopefully these issues can be resolved internally where you don't actually need an external legal. So, and that's why I said before, in terms of this feels more like a people and culture issue, and not to handball it to Grace's side, but 99% of these issues will hopefully be able to resolve internally. And it's just those small cases where you might actually need external counsel to help out because it's gotten quite serious. So yeah, I think there's not as much overlap between HR and legal as what a lot of lawyers think there is. I think sometimes there can be a bit of a contention between the two, a bit of tension saying that, you know, well, I could do that. No, HR should be doing that. But I actually think of it more as HR as the doers and the ones that actually hold the relationship, and they know all of those intricate things about the organisation. And then the employment lawyers are more like those top-up pitches that come in only when absolutely needed to kind of deal with that very niche, nerdy area. So I think that's a good relationship between the two, can understand kind of the strengths and weaknesses of both, and to know that it's not a push and pull in terms of who does what or when you need it. It should be kind of a nice relationship in which you kind of just calling the levers when you need it.
Definitely. And also kind of relying on each team's sort of strengths. And so if you feel like you need that employment support, then reaching out to an employment lawyer, but you feel like you've got the capability in-house, then certainly leveraging that as well.
Completely. And so just to jump in, like, Grace, not to toot you on, but you're an employment lawyer by trade. You're also now an HR function. It would seem silly that in your situation, with all your experience and know-how and just ability to comprehend all of these things, that you would then get an employment lawyer in. So I think it just is a good example of the fact that Oxfam's needs from an employment law basis externally are very different to, say, an organisation that has no capability. So I'd hate to say that each organisation should use us the exact same way. Hopefully it's a bit more tailored than that.
Definitely. Now, I'm sure all our viewers have heard the expression, what gets measured gets done. In terms of the right to disconnect, or perhaps even just employee satisfaction generally, at Oxfam, how are you thinking about measuring or reporting on progress, Grace? What are some metrics that Oxfam are looking at when looking at the right to disconnect or just satisfaction general?
Yeah, so I think, look, we're definitely on a journey, and it's just purely from the size of the team, right? And our priorities and how we can service our clients internally much better. So we're on a journey, obviously, to try and become a more proactive team, and we're taking steps towards that. But sometimes, as many P&C professionals and teams can know, you're often dictated by BAU or other people's priorities. And so you end up being active, like not acting actively, you're often acting reactively. And so that future planning work kind of gets put to the side. But, you know, look, that's a constant thing that we're grappling with and managing as we're going forward. So we're still working on that. And so that's obviously a work in progress. But the things that we sort of do try to measure on quite a regular basis are things like employee NPS or Net Promoter Score. So, you know, would an employee, whether they're exiting or still in the business, would they recommend, you know, family or friends to work here in the future? That seems to be, from what I understand, to be the gold standard in P&C cases. But, you know, I'm still learning about this as well. But it's really interesting just to see the metrics from that. We also do a lot of comprehensive board reporting every quarter, and that's on some more granular things. So, you know, not only what our priorities are now and coming up in the next 3, 6, 9, 12 months, but also things around retention, around turnover. Andy sort of mentioned it before as well, around cost of recruitment or hiring for individual roles. So we're doing a lot of work around that at the moment in advance of end of financial year and the next board meeting. And then other than that sort of stuff, you know, we're working around getting data and understanding about how our onboarding and offboarding process are working. There was a big piece done before I started a couple of months ago around making sure that's as efficient as possible, and it really works for the person coming in and exiting the business. But also that's around our strategic alignment as well. So again, with that future planning process and that workforce planning process that we're trying to do internally in our team to become a more proactive team, we're doing, you know, strategic alignment as a team at the very least every 6 months. So making sure that we're on the same page around, you know, setting our priorities. We're sort of working towards making sure that we've got our own P&C strategy at the moment, but, you know, we're working on our priorities in line with the 5-year strategy, which is coming up for the organisation more broadly. But, you know, I think another thing from our perspective is we've got a really good relationship with the union. And so I think that's really key, having a good relationship with the employees as well, and really staying close to the teams, especially as a business partner, is quite a strategic way of understanding what's actually going on in the teams, because you might get one story from managers, but really what's happening on the ground? What are the gripes that people are dealing with? How can we assist there to make it a better environment for them to thrive and work in as well? But they're sort of the things that we're grappling with at the moment.
Very cool. And no, that makes sense. And Andy, is there any sort of legal requirements here, or from your experience, have organizations typically sort of reported on some of the metrics around satisfaction, or just in general kind of measuring the right to disconnect, like having some sort of system in place, I suppose?
Yeah, so if we were to focus on psychosocial hazards, for example, because I think that is an area where we're seeing some interesting thought put into it, oftentimes by psychologists and people much more skilled or qualified than me, trying to look at how can we actually measure if the things that we're putting in place to protect against some of these hazards are actually effective. So yes, it's fine for us to say we did training for managers, but how do we show that that was actually effective? Is there some metric we can look at to show that we're improving in that space? So some very basic ones people are looking at sometimes are personal carers leave and how much of that is taken. How many workers' comp claims are we getting? How many complaints are we receiving? And that's not necessarily always a good thing if you're not getting any complaints. In fact, I think a healthy organisation would probably end up having a certain number. What you don't want is for there never to be any complaints, because it oftentimes means that people don't feel comfortable to come forward, or they only have one avenue to go, which could be their manager who is bullying them. So some of those metrics I think are really important. Personal carers leave, for example, we oftentimes don't know based on the medical certificate why they were off work, and not necessarily that we should know, but it can be a good kind of indicator sometimes that something may not necessarily be right in terms of their health and safety in the workplace. So can we think about those kind of aspects? And then in terms of surveys and things that we look at to try to get satisfaction, the more sophisticated clients are actually doing this team by team, rather than as a whole, because there, as we all know, there could be 15 teams in your organisation and 14 are perfect and they've got the best managers in the world. People are happy to go there. They stay for 15 years. And then you've got one team that has the worst manager, turnover's crazy high, their workloads are demanding, and that can sometimes be softened by looking at the whole. So ways in which I guess we can be smarter in terms of trying to actually find information which we may not love to see is way better than just ignoring it until we get 15 workers' comp claims in one team because we tried to ignore it. So I think each organisation will have different metrics they can look at in this space. But yeah, there are some of the ones that we're seeing at the moment. I don't think what we're learning in the psychosocial hazard space is just having an EAP and monitoring how many calls they receive is not a good enough indicator anymore. It is a good thing. I'm not trying to say EAPs are a bad thing for organisations to have. I think they're a useful tool. They're also not super expensive. So sometimes I struggle to see why some organisations don't offer it. But I don't think that's going to be enough anymore moving forward. You can't just have EAP and say that we're fine. I think, yes, good that we refer to it in our letters and our communications, but probably not enough on its own. So yeah, just a few things I think we're looking at the moment to make sure we're providing a safe workplace, which then falls through in terms of this right to disconnect.
Definitely. So it's a bit more nuanced, for sure. Now, I'm conscious of time, but I think it's definitely important that we at least cover off a few more of the other sort of changes that have come about as a result of both the Closing the Loopholes Acts. I want to focus on two key ones, changes to fixed-term, maximum-term contracts, which I would love to get your thoughts on, Andy. And then just to give you a heads up, Grace, I'd love to get your thoughts on flexible work changes after that. So perhaps if I start with you, Andy, what were some changes to the fixed-term, maximum-term contracts that were made last year?
So in December of last year, we got some changes in. Basically, they introduced limitations on when organisations can offer fixed-term or maximum-term contracts, so contracts that have an endpoint. What they kind of saw were a lot of organisations were using this engagement tool incorrectly. So they would effectively have employees on rolling one-year contracts for 5 or 6 years. So they were treating them like a permanent, but they just liked having the option to just let them go at the end of every year. And I could say that those organisations were already basically engaging them as permanent because they were treating them as permanent. But this is a much clearer delineation between what is acceptable and what's not. So after December, you can only have an employee on a fixed term, maximum term contract for a maximum of 2 years in total, and you can only extend them one time. So you could, for example, have an employee on a 1 year fixed term contract and then renew them for another year. But then at the end of that point, you effectively have to either let them go or for permanent employment, or you could just put them immediately on a 2 year fixed term or maximum term contract. There are some exceptions. So a lot of not-for-profits heard this news and they basically kind of, their hair caught on fire because they think that, well, our funding is not certain. So how could we engage people permanently if our funding is only for 2 years, for example, or a year? There are some exceptions in the Act to try to make it easier for some organisations. But I would just flag in for not-for-profits, it's still quite limited in that exception. So there's an exception if you're covered by government funding or the role is funded by government funding, that is at least 2 years and it's unreasonably likely to be renewed. Now, you might say, how do I even know what that is? And to be honest, I'm not sure. We haven't had cases test that before. But I'd be looking at, have you had it renewed multiple times before? Have you been given assurances that you're basically the only provider that can do that work and so you have to be renewed? I'd be looking at that. But otherwise, I think organisations effectively now are going to have to reduce the amount of fixed term, maximum term engagements they use and just be a bit smarter about it. So it doesn't affect people that are already on them. So you would effectively, when it gets to that near expiry date, you'd have a look to see kind of what's happened in the past. But otherwise, it doesn't mean that you have to immediately shred up contracts and offer permanent. I would just wait until the expiry date happens to work out what you need to do. But yeah, that's just a limitation that came in December that a lot of our organisations are not fully up to date with. And it does impact a lot of our not-for-profits more than any others because they're just so used to using maximum term fixed term contracts that align with government funding. So yeah, I would just recommend those organisations carry out a bit of an audit to see of all their maximum term fixed term contracts when they expire, how long they've been there, how many extensions have they had. And then if they are going to fall under an exception, so in relation to that government funding piece, potentially amending their position descriptions to actually refer to the funding that they're funded under will give you a much easier argument to say that it's connected to that funding. I don't think they'll love it, or I don't think you're in a really strong position if you just say at the end of that you're under the exception, but then struggle to link it to a particular funding model. So those are like very easy ways you can try to protect it. But yeah, I'm just conscious that's a big shift for a lot of our clients to try to get on top of.
Definitely. And thank you for explaining that as well as sort of going through some of those exceptions broadly. Just conscious of time, so I might jump to Grace quickly on the flexible working arrangement change. So we had flexible work kind of in the Fair Work Act, but we've seen a shift in that. So could you talk a bit about what changes we've seen? And also, there's a recent seminal case at the Commission, Charles Gregory and Maxia, which was quite important in terms of how it set the scene for flexible work and so the rights of employees and employers alike. So could you, in brief, talk about some of those changes and why they're so important?
Yeah, absolutely. So I'm definitely not an expert in this area. I know of the Maxia case as well, but I think definitely Andy and yourself as people working in this every day is definitely something you would both be able to speak more to. But look, my understanding of the changes that sort of came about with the Closing the Loopholes Acts have been around tightening those obligations around flexible working arrangements, absolutely. And so it's going to be interesting to see, and we've already seen as well, I know when I was working at Law Squared, there was some clients who were managing this, and it's quite well managed here and across the NFP sector, I think, because they've had that flexibility for a while. But in brief, it's around making sure that employees aren't taken for a ride, really, if we're talking about it. And I think it's particularly an obligation on employers, really. So there's always been very strict deadlines around, you've got 21 days to respond to flexible working arrangements, requests in writing, you've got to give reasons for it, but it's just really tightening around, what are the reasonable business grounds that you can potentially reject those or potentially, push back on those a little bit. But then there's a further clarification around needing to have that conversation with the employee and try to genuinely come to a compromised arrangement that is going to work for both sides. Ultimately, if it's swayed on one side or the other, it's not going to create good people outcomes, again, as we've talked about this today. But I think it's got to be something that's workable for both parties, really. And my understanding of the Maxia case, please correct me if I'm wrong, is around I think some employers thought it was, a silver bullet saying, oh, yeah, perfect, we can absolutely reject these flexible working arrangements. In my mind, from my brief understanding of it, it's not, but it's another opportunity for you to have that conversation with the employees, right? And if you're a good employer that's focusing on people outcomes, you will naturally have those conversations with your employees who do try to ask for flexible working arrangements under the Act. But I've found in the NFP sector, because they are so very focused on employee interest, absolutely. You see that through enterprise agreements. You see that with the way that they interact with their employees. It's largely focused on being flexible as well. And I think that's why a lot of people come to work in the NFP sector, because there's already that ingrained flexibility. So I think potentially there's something to learn from the NFP sector that corporates could get out of this as well.
Yeah, definitely. Now I've just seen we've hit time. So I just want to thank you both so much for taking the time to share your wonderful insights with all of our viewers today. If you haven't already done so, don't forget you can download, viewers, the Right to Disconnect policy template that Law Squared has prepared. You'll see the link in the chat bar. This is an excellent sort of place to get started. And if you have already done that and now need some further assistance or are ready to start thinking about training and some of the other stuff that we talked about today, please feel free to reach out to Andy, myself, or our colleague Jess John at Law Squared. I would be happy to have a chat. And finally, a big thank you to all of our viewers. I've seen a number of your questions sort of trickle through, and although I think we've covered off a lot of them, I'm looking forward to going through them in more detail and getting back to you at a later stage. But I want to thank you all for coming, and goodbye for now.